All right, well, it's 1:30. Let's get started. Hello, everyone, and welcome to today's webinar titled Top 10 Medicare Secondary Payer Myths Debunked. My name is Heather Schwartz Sanderson, and we have a great program ahead. I'm really excited about going through some of the myths I've encountered in Medicare Secondary Payer, debunking them, and providing you all with some best practices to take away after the webinar so that you can improve your MSP compliance. A few housekeeping items before we get started. First of all, I will be taking questions at the end of the presentation. If you have a question, you can populate it into the Zoom Q&A chat function, and I will check those at the end of the presentation. And any that I don't get to, I will address those via email after the webinar. Speaking of email, if you would like a copy of this presentation, I would gratefully ask for you to email me after the presentation, and I will directly send you the presentation. I didn't want to send it out en masse, so please email me if you'd like a copy. And lastly, I will be sending out a survey via Zoom after this webinar, and I will be seeking feedback on today's presentation, as well as information on what you would like to hear about on future webinars. Very grateful for the number registered here today, and I think we've got a lot to dive deep into. Before we get started, I'd like to take a moment to introduce myself for those of you that don't know me. Again, my name is Heather Schwartz Sanderson, and I've been in the Medicare secondary payer industry for close to 15 years now. And I've held a number of roles over the years, namely working for a number of Medicare secondary payer compliance vendors in the space, many of that you might know. And over the last 6 years, I served as Franco Signor's Chief Legal Officer until last year when we were acquired. And after the acquisition, I decided it was the right time and the right opportunity for me to take my expertise and launch Sanderson Firm. I really, really enjoy doing what I do. I really enjoy Medicare secondary payer because I think that it can be complex and cumbersome for many. And I truly enjoy when I'm able to take such a complex topic and distill it down to simple methods of compliance, simple understanding of what Medicare secondary payer is. I have written over 200 articles on Medicare secondary payer over the years. I love to write. I've also served as an expert in Medicare secondary payer in various cases, and I am pleased to have been able to speak to many audiences such as yourselves across the country at conferences nationwide, and I really enjoy the topic. So without further ado, let's jump right in. My email address is on the screen again if you would like a copy of the presentation after the webinar. Well, I think it's very important that we talk about what Medicare secondary payer is. Many of you know what it is, but let's lay the foundation and talk about what brought us here today. So the intent behind the Medicare Secondary Payer Act was to ensure that there was no cost shifting of the burden to the Medicare Trust Fund in primary workers' compensation, general liability, and no-fault claims and settlements. I think it's important to also think about where the MSP started and where we're at today. Some noteworthy years for the Medicare Secondary Payer Act. In 1965, we had the start of the Medicare Secondary Payer Act, but only applicable to workers' compensation. And then in 1980, the Medicare Secondary Payer Act was expanded to apply to general liability and no-fault claims as well. And then we saw the MSP largely unenforced until 2001. And in 2001, the Centers for Medicare and Medicaid Services released what's known as the Patel Memo. And in the Patel Memo, Medicare introduced the concept of a workers' compensation Medicare set-aside that could be submitted to CMS for review and approval. And that was the beginning of Medicare set-asides 20 years ago. In 2007, the Medicare, Medicaid, and S-CHIP Extension Act of 2007 was passed, now requiring primary plans to report claims and settlements with Medicare beneficiaries to Medicare. That was in 2007. But it wasn't until 2010 where the requirement was enacted. And now we'll talk about it a little bit later in the presentation, but failure to report pursuant to the MMSEA Section 111 reporting requirements could result at the time into penalties of $1,000 per day per claim. Pretty steep, right? In 2013, another important year, I was very grateful to have been a part of MSP reform the last 10 years. In 2013, we passed the Strengthening Medicare and Repaying Taxpayers Act, also known as the SMART Act. And now what the SMART Act did was a number of reforms to the Medicare Secondary Payer Act. I won't go into all of them now, but many of you are aware of Medicare now having a statute of limitations on their recovery at 3 years. There was also a change in the civil monetary penalty component of Section 111 reporting to make penalties discretionary rather than mandatory. So now the language was up to $1,000 per day per claim rather than mandatory of $1,000 per day per claim. In 2015, we saw CMS strengthen their recovery muscles with regard to conditional payments, those payments that Medicare has made pre-settlement. Initially, we just had the BCRC, the Benefits Coordination and Recovery Contractor, recovering conditional payments, and typically once settlement occurred or a claimant passed away. But in 2015, the Commercial Repayment Center, also known as the CRC, came on board, and the CRC began collecting conditional payments in open workers' compensation and no-fault claims. This was a big change. Medicare, I think, realized that there was a lot of money sitting there uncollected, and now we have these multiple demands for conditional payments potentially occurring throughout the life of a workers' compensation or no-fault claim. Lastly, 2020 was a big year for Medicare secondary payer with the passage of the PAID Act, and I'll talk about that in a moment on the next slide. But altogether, we all need to know that there's 3 major components to compliance with the Medicare Secondary Payer Act. Reimbursing Medicare for conditional payments, the reporting aspect, the MMSEA Section 111, that electronic data transfer of information regarding claims and settlements with Medicare beneficiaries to the Centers for Medicare and Medicaid Services. And lastly, the protection of Medicare's future interest via a Medicare set-aside, also known as an MSA, or other future medical allocation. Okay, so last year was very exciting. Well, it was a bad year for many of us, and I think that applies universally. But one good thing that came out of 2020 was the passage of the PAID Act. This is something that I held near and dear to my heart. My time at Franco Signor spent a lot of time lobbying for the PAID Act. And now this picture here is when I met Charlie Crist in the Washington, D.C. airport. I was on my way to a MARC Coalition meeting and to go up to the Hill to advocate for PAID Act, and this was taken in 2018. I thought that was pretty cool that I ran into him in the airport, and I chased him down and talked to him about the PAID Act, and so that was fun. But getting back to the PAID Act, really big accomplishment out of 2020. So now PAID Act stands for Provide Accurate Information Directly Act. The PAID Act was signed into law by President Trump on December 11, 2020. It has a 1-year implementation date, and come December 11th, 2021 of this year, the PAID Act should be implemented. Now, what is the PAID Act about? I talked about this a lot. Just last year, in 2020, I personally took part in almost 60 meetings with congressional staffers on the Hill, most of them virtual due to the pandemic, but talking about the PAID Act and why it was so important. Essentially, currently, when you query a person's Medicare status before you report via Section 111 reporting, Medicare currently is only returning traditional Part Medicare A and B enrollment information to you. It is not displaying Medicare Advantage, also known as Part C, or Medicare Prescription Drug Plan enrollment information, also known as Medicare Part D. We need this information because, as we've seen over the years, and I'll talk about it a little bit more in the presentation as we go on, Medicare Advantage and Part D plans have been pursuing their recovery rights. And accordingly, it's important for primary plans to be able to know that a Medicare Advantage plan or a Part D plan is out there. So this was a very exciting development of 2020, and I just wanted to make sure to highlight it and celebrate it with you all virtually. And before we dive into myth number one, I want to say thank you to CMS. I have to give credit where credit is due. First of all, we have a couple of members from CMS on the call today, and I want to thank them for joining. And I think that it's just a sign. Medicare has been wonderful about their outreach to the industry the last couple of years. Personally, I've seen a significant increase in the outreach. We see them working with the MAR Coalition, also known as the Medicare Advocacy Recovery Coalition. They are the coalition that promulgated the SMART Act and the PAID Act. We've seen them working with the MSP Network, formerly NAMSAP, and other industry stakeholders. We've seen an increased frequency of town halls. We've seen constant updates to guidance as far as the WCMSA reference guide, the NGHP user guide. And then Medicare has even said, you know what, with the PAID Act passage, we are committed. We are going to aim to implement PAID Act by its implementation date of December of this year. And you know what? We're going to issue hopefully some alerts to the industry come summertime so that responsible reporting plans can get ready to respond to the PAID Act implementation and have their fields ready to receive that Part C and D information. So thank you, CMS, for being, so great as far as trying to clarify MSP obligations. I really want to say thank you. And just recently, I reached out to CMS on a very unique MSP matter for a client, and they were very responsive. So thank you. And now let's get into the presentation. First of all, I have listed here some MSP acronyms and terms. I'm going to attempt to define these terms as we go throughout the presentation. Many of you are familiar with them, but for those of you that are taking this presentation home after the webinar, I want to make sure you understand what my acronyms mean. But we're not going to spend time here. Okay, myth number one, CMS is bound by your settlement agreement or agreed upon order. Well, it's not exactly the case, right? So that's why it's a myth. Medicare is bound by your settlement amount under the Code of Federal Regulations, right? They are bound by they're capped at the total settlement amount. However, Medicare's rights of recovery under the MSP are absolute. Medicare can pursue any party receiving settlement proceeds. So essentially, you can rely upon a Medicare beneficiary or their attorney or designate them to be the party responsible for reimbursing Medicare their conditional payments. But if the Medicare beneficiary or their attorney doesn't reimburse Medicare, Medicare has the right to pursue any party to the settlement. Also, it's important to note that your settlement agreement that might be approved by a judge or the Work Comp Commission is not binding upon CMS. CMS requires an evidentiary order issued after a hearing on the merits of the case. Now, what does that mean? This is something that I've encountered over the years, and unfortunately, it's a tough situation to explain to a client because they may have worked very hard to come to terms to an agreed upon order or the agreed upon liability in a particular claim, but Medicare is not bound by that agreement. Where this comes up a lot, these evidentiary orders issued after hearing on the merits of the case, typically occurs, I see, with workers' compensation Medicare set-aside submissions to CMS for review and approval. We've seen, parties want to hopefully obtain a zero allocation or a zero MSA, and they will provide, I've seen situations where they've agreed upon no liability. Well, that doesn't work. What needs to happen for Medicare to be bound by that order is that there needs to be a hearing and there needs to be evidence presented and there needs to be an evidentiary finding for Medicare to be agreed upon that order and to be bound by it. So it's very important. I think that this is a key component of the Medicare Secondary Payer Act. And now, as I promised, some best practices to take away from myth number one. I am a huge proponent for clear settlement language It should very clearly address the parties' steps in MSP compliance. The settlement agreement ideally should lay out how the parties have protected Medicare's interest if there's a future medical obligation. Most particularly, and I would say the most important part, would be conditional payment obligations. While I just told you that any party to the settlement can be recovered from if Medicare is not reimbursed, and also just simply designating the Medicare beneficiary or their attorney as responsible does not alleviate concerns, there should still be a clear outline as to who is going to handle the conditional payments, particularly if a demand crops up post-settlement. Seen this happen time and time again. I've read numerous cases where parties have relied upon an initial conditional payment letter from CMS stating a particular interim conditional payment amount. The parties settle with that number, and there is no clear delineation as to who is responsible for those conditional payments post-settlement. And I've seen it actually unwind and undo the settlement. So particularly around conditional payment obligations, and I will talk a little bit about Medicare Advantage. That's a rub that needs to be contemplated in your settlement agreement as well. But I really, really, truly recommend custom and non-template settlement language. I've also seen time and time and again where adjusters mistakenly use the wrong template for the wrong scenario, or it's not applicable. And again, this is another situation where the settlement can be undone. So you want to use custom language where possible. Perhaps you want to implement some dollar threshold in your organization where you would need custom language as far as risk goes, but very important to do that. Also, if you're going to submit an MSA to CMS and you want to rely upon a settlement agreement or an order, make sure that it's an evidentiary hearing on the merits. Now, it might be a situation where it's not ideal to submit to CMS, and I'll talk about that later in the presentation. There are certain scenarios where that might be warranted. With that, let's move on to myth number 2. Myth number 2, Section 111 reporting does not impact conditional payment recoveries. Big oi. So now this has become increasingly important over the last few years. In the early days of Medicare secondary payer, where there was no conditional payments and it was essentially a Medicare set-aside world, there was no coordination between Section 111 data and conditional payments. But as I mentioned earlier on, in 2015, particularly with the Commercial Repayment Center coming on, we're seeing that the CMS contractors are utilizing that Section 111 data to drive their conditional payment recoveries. And most recently, so just a couple of years ago and released in 2020, was a Notice of Proposed Rulemaking. You'll see this here listed as NPRM. That stands for Notice of Proposed Rulemaking. Medicare issued an NPRM seeking to set forth standards in which a responsible reporting entity, also known as the RRE, the party responsible to report, the primary plan, where they could be sanctioned if there is a disconnect between what is reported on Section 111 versus what is being stated in a conditional payment dispute scenario. Let me give you an example, and I believe this is the one that was highlighted in the NPRM. An RRE may report ongoing responsibility for medical, letting Medicare know that the policy has been triggered in a workers' compensation or no-fault claim, letting Medicare know that. And then unfortunately, there might be the scenario where the adjuster or the person handling the file forgets to terminate ORM, forgets to terminate that responsibility. And then later, a conditional payment demand comes in and the parties say, you know what, we didn't have responsibility during that time period. And so they dispute the conditional payment with the contractor, letting them know there was no responsibility during that time period. But the Section 111 data tells a different story. And now what Medicare stated in this NPRM is those sorts of scenarios can subject an RRE to penalties of up to $1,000 per day per claim. So it's becoming increasingly important to make sure that your Section 111 data is clear and timely and accurate. It needs to be consistent with your settlement information and consistent with what you're telling Medicare in your conditional payment dispute process. Again, it's important to note that both the BCRC and the CRC utilize this Section 111 data to identify conditional payment recovery opportunities. We've also seen they use the data as well to determine where there needs to be a coordination of benefits. There have been some occasions we've heard of scenarios where, inaccurate codes are reported and ORM has been flagged in a file, and unfortunately, Medicare may have denied treatment for someone's unrelated medical care that's not related to the injury. And that's due to the Section 111, right? That just goes to show that they're using it. Those are generally mistakes and usually can be rectified. We haven't seen that happen as much. But the key point is that your Section 111 reporting is impacting conditional payments, and it is important to make sure that the two coordinate and are consistent. Also, the Medicare Advantage and Part D plans also use Section 111 information for driving conditional payment recoveries as well. So, some best practices for myth number 2. And again, I'm going back to settlement language. It could be the lawyer in me. I can't help myself, but it's super important. I have seen it time and time again. It needs to be clear. Your ICD 9 or 10 codes needs to be consistent across your conditional payments, across what you're doing as far as the future medical allocation and Section 111 reporting. And also, it's very important that you're updating your ICD codes throughout the life of the claim to make sure that Medicare knows timely what the accepted codes are. Highly recommend that RREs, again, that term means responsible reporting entity, should control the reporting to Medicare. Obviously have an obligation to report to Medicare, but we know that oftentimes Medicare beneficiary attorneys will self-report a claim to the BCRC. Now, this can unfortunately cause multiple files to open, and so that could be a problem. So we want to make sure that you're controlling what you're telling Medicare is related to the claim, and also that if you are aware of any self-reports by the Medicare beneficiary attorney, that it's cleaned up. We should also ensure timely reporting and termination of ORM. And I'm going to talk about that a little bit more in a moment because it's so important. Here it is. Myth number 3, timely ORM termination does not save time, money, and headaches. Oh, this is a really big one. So ongoing responsibility for medical indicates to Medicare the primary payer's responsibility to pay for injury-related medical care on a particular claim. It's very important. This is how Medicare knows that there's a primary payer. Medicare not only expects timely reporting of acceptance of ORM, but also timely reporting of the termination of responsibility for medical. Very important that the CRC uses this information to drive their recoveries in workers' compensation and no-fault claims. Just recently, I believe it was January of this year, Medicare released an update regarding ORM stating that RREs can now terminate ORM up to 75 years in advance. So if looking at the insurance contract, you know there's a finite point for ORM termination, the RREs can populate that in advance. It's very important for claims organizations to ensure consistency as far as reporting of ORM termination. The file remains open at Medicare, and it's going to be a problem. It's going to cause time, money, and headaches to unwind that. So best practices for ORM. It must be accurate and timely to avoid conditional payments. A lot of times I've seen, parties come looking for help with a conditional payment dispute. And one of the things that I usually flag for them is that their Section 111 data is inconsistent with what they want to tell Medicare in the dispute process. And that is very common. And again, this is not unusual, and it's not to any fault, but very important. And the termination date is the date in which the primary plan ceases to be responsible for a Medicare beneficiary's ongoing medical care as it relates to the injury. And again, while errors in reporting do occur, and Medicare understands that, and it's potentially can be used as a defense to a conditional payment dispute, It's more difficult to fix on the back end. And also, as I mentioned earlier, it can cause penalties to issue. So we need to really get a hold of ORM termination now before Medicare finalizes that NPRM. The NPRM that I mentioned on civil monetary penalties, that which the comment period closed in April of 2020, many want to know what's going on with it. When is Medicare going to finalize that rule and start issuing penalties? Well, I don't have the crystal ball for that, but I know it will be no later than 2 years from now because Medicare has until 2023 to finalize that. And it could be sooner. I know that it's something that they're working on. It's a key point and a takeaway from the SMART Act. Medicare must set forth all of the parameters around when they would sanction a responsible reporting entity. So we're waiting for that, not so anxiously, right? But in the meantime, it's good time to clean up your reporting. And a late report is better than no report. And it looks like any penalties will be issued prospectively. So that's very good. Let's move on to our next myth. Myth number 4, conditional payment correspondence should all be treated the same. So, as I've mentioned before, the Commercial Repayment Center is pursuing recovery in workers' compensation and no-fault claims where ongoing responsibility for medical is reported. And as I mentioned earlier on, in 2015 is when we saw the CRC start to issue these notices, right? And so, very important, I'm going to talk about the different types of correspondence briefly and how they all need to be responded to differently. But the BCRC, on the flip side, pursues recovery in general liability claims, particularly when there's a report of total payment obligation to claimant, also known as TPOC, which is the reporting of a settlement. And in those cases, the BCRC is controlling those. But another thing to understand is that even if you are working a no-fault or workers' compensation claim and it's currently with the CRC, once that claim settles and a TPOC, a settlement notice, has been reported, if there's any remaining conditional payments, it's going to flip to the BCRC. So it's very important to understand which contractor you're dealing with. It's very important to understand the type of correspondence received so that you can respond appropriately and don't miss timeframes. Let's talk a little bit about that. Again, understand which contractor your notice is coming from. Identify the types of correspondence. A rights and responsibilities letter is not a request for payment. It is simply a notice to the primary plan, letting the primary plan know that Medicare is aware of the primary payer situation. And later on, they may issue further notices. Now, coming out of the CRC, especially since 2015, are what's called conditional payment notices, also known as CPNs. These have a strict timeline for response, 30 days to dispute or pay, or it turns into a demand. Now that demand has a strict time frame around it as well. 60 days after that, if it's not responded to, and we're going to start seeing interest starting to accrue shortly thereafter, and eventually can move to the Treasury Department, and it gets ugly after there. We definitely want to understand what type of correspondence you have in front of you. It's not always going to clearly say rights and responsibilities letter, conditional payment notice, CPL, right? You need to read the actual letter and determine what is there. Responding timely and disputing unrelated charges accordingly is very important. We know, and Medicare has admitted, that sometimes the technology is not completely accurate. You may report only some accepted ICD claims, and there may be a conditional payment notice or letter that has been issued to you with unrelated charges. Medicare is great about removing those unrelated charges once you dispute. And there are other methods in which you may want to dispute conditional payment. I talked about earlier the statute of limitations on Medicare's recovery, which is 3 years from notice of settlement, judgment, or award. Anything beyond that, and Medicare cannot recover. We also have many other state law defenses and other applicable defenses that can be present. How about also in no-fault claims, when the policy limits have been exhausted? and the parties have not received notice that Medicare had a claim for payment. The recently updated MSP manual states that Medicare is capped at the policy limits or settlement amount. Employ an expert to help you. Can save you a lot of money, but you want to make sure to respond timely and dispute accurately. All right, Medicare Advantage conditional payments. Now, this is a hot topic for me because I mentioned earlier on that I was a big proponent for the PAID Act, and part of that came from, seeing Medicare Advantage coming out over the years and strengthening their recovery rights. And I've actually recently served as an expert in the MSP recovery versus State Farm class action, which I just saw. I've been out of it as an expert since 2019, but I just saw was dismissed. But let me talk a little bit about the Medicare Advantage litigation and why I think it should be an area of concern under the MSP, especially in years to come, and why I was such a big proponent for the PAID Act. So the Medicare private cause of action within the MSP states that there is a private cause of action for double damages where there has not been a prompt reimbursement. Now, the Medicare Advantage plans have taken this to say that they also should have rights to double damages where they're not reimbursed for conditional payments. And we've seen over the years, and in 2012, there was a decision well known as In Re Avandia coming out of the Third Circuit Court of Appeal, finding that Medicare Advantage plans have the same rights of recovery for double damages as traditional Medicare. Then we saw in 2016, the 11th Circuit Court of Appeal, also in the Western Heritage case, finding similarly to In Re Avandia that Medicare Advantage plans also have this right where they're not reimbursed. Now, these decisions out of these two circuits definitely affect New Jersey, Pennsylvania, Delaware, Alabama, Georgia, and Florida. So clearly in these jurisdictions, there is an established right to double damages, and we want to take extra caution in those states. But what we're seeing is that the case law is continuing to come up, and Medicare Advantage plans are pursuing these private cause of actions across the country. And so we have rights developing in other states as listed here. Let me take a moment and talk about MSP Recovery, LLC, who is the entity that was the plaintiff in which I served as an expert a couple years ago. And many of you have heard of them. They are a law firm out of Miami, Florida, and they have been going around to some of the smaller Medicare Advantage plans and being assigned their claims. They say to the Medicare Advantage plan, I bet you've got a bunch of unreimbursed conditional payments. Assign us your claims. We'll file the lawsuit, and no damage to you unless we actually win. So if you go on their website, I believe it's msprecovery.com, you can find over 100 lawsuits pending nationwide. And part of my work is continuing to serve as an expert in this area as these cases continue to go. And some of it is somewhat scary because we're seeing the law stretched a little bit. There was a recent case I blogged about. It was entitled MSPA Claims versus Tower Hill. MSPA Claims is essentially MSP Recovery LLC. They have various corporate entities, but they allege that the 3-year statute of limitations does not apply. All the parties seem to agree. This was a case out of Florida, by the way, that the 3-year statute of limitations was not applicable to the private cause of action. And so finding that there was no clear private cause of action statute of limitations, the court had to look to other statute of limitations. Tower Hill, the insurance company, argued that they should borrow from Florida statute of limitations, and they applied a 4-year statute of limitations. MSP Recovery argued 6 years under False Claims Act. Ultimately, the court sided with Tower Hill in finding the statute of limitations to be 4 years in this particular case, but it's a little bit troublesome because what I'm thinking coming out of this lawsuit is that we might have courts across the country finding that the private cause of action does not have a clear statute of limitations, and then we have various case law with differences across the country, and now you're going to have different statute of limitations in each state. I hope it doesn't get there, but it might. But anyway, the Medicare Advantage plan conditional payments are certainly a concern to the extent you're aware of them. Let's take a look here at some graphics I've provided. Medicare Advantage enrollment is growing big time. Right now, we're at almost 40% of the Medicare population is enrolled in a Medicare Advantage plan, and it continues to grow year after year. Arguably, Medicare Advantage plans can offer a little bit more competitive benefits for Medicare beneficiaries, so we're seeing that enrollment increase. So think about that. 40% of your Medicare claims population could be on a Medicare Advantage plan, and that's why the PAID Act is so important, so that parties can proactively resolve those conditional payments if we need to. So now, what to do about Medicare Advantage conditional payments? If you receive a notice, generally the conditional payment correspondence will come from the Medicare Advantage or Part D plan itself. For example, if Humana was the Medicare Advantage plan, it would come on Humana letterhead seeking reimbursement. There also might be a recovery contractor working on behalf of the Medicare Advantage plan. It's very important to read the notice. Take these notices seriously, particularly those from MSP Recovery LLC, because they have been so litigious. And I would say, though, that you don't need to respond to all of the notices from MSP Recovery LLC. I have seen some clients receiving notices that are purely fishing expeditions, saying, you tell us where you're primary, because they don't have the data, and there's no obligation to respond to that. It's the Medicare Advantage plan's job, arguably, or the assignor to find those primary plans. So take a look at these notices very carefully, employ an expert where needed, and definitely don't ignore them or throw them in the trash. One thing that I've been wondering, when the PAID Act gets implemented later on this year, then will the Medicare Advantage plans and Part D plans be ready for the volume of calls? Historically, it's not been a proactive reaching out by primary plans to Medicare Advantage and Part D plans. Typically, we receive notice of a conditional payment and we respond back. And some Medicare Advantage plans have been more active in their subrogation of conditional payments over the years. We've seen more of like the bigger ones like Humana and United Healthcare. But then some of these smaller Medicare Advantage plans haven't really actively been pursuing conditional payments. So we're wondering, will their subrogation departments be ready for the onslaught of calls when you find out that your Medicare beneficiary is enrolled in that Medicare Advantage plan after the PAID Act is implemented, and you want to verify and resolve any of those conditional payments? Will they be ready to take the calls? I hope so. Medicare has stated that when they provide the plan information, they're going to provide contact information. And so I think that's going to be very helpful. But it's important to note that if you don't address Medicare Advantage or Part D plans until the last minute, or until settlement, it can cause major issues in your settlements. It can also cause issues, unfortunately, many years post-settlement if you don't proactively resolve the conditional payments and the demand is maybe issued after you've settled your case and closed down your reserves. Not fun, right? That's not what we want to happen. So what I've been recommending to my clients is, particularly until the PAID Act is enacted, it's helpful to identify an injured party's Medicare Advantage or Part D plan, particularly in the 6 states that I mentioned, which have an established right of double damages. You can ask the Medicare beneficiary, or their attorney to reveal any plans they've been enrolled in for the life of the claim. We want to know, right? And this could be a key component that you would ask for prior to settling with that person. It's not required, but again, if you want to proactively avoid these issues, it's a good idea. And if you're receiving pushback from a Medicare beneficiary attorney, let them know that they have a stake in the game as well. We've seen Humana make an example out of a plaintiff law firm that failed to reimburse Humana Medicare Advantage their conditional payments. There was a case called Humana versus Paris Blank. I believe it's settled. But again, everybody has a stake in the game, just like traditional Medicare. Now, just recently, CMS released a new model form. Now, this model form, we had one historically, and it's designed for situations where the primary plan is attempting to obtain a Medicare beneficiary, or if not known, an individual's party's Social Security number so that they can query the person's Medicare status. And now Medicare had previously provided this model form that primary plans could use to document their file. So the Medicare beneficiary fills it out and attests they're refusing to provide their Social Security number and revealing whether they've been enrolled in Medicare Part A or B. Medicare just updated that model form so that the claimant can attest to general enrollment in Medicare, not just Medicare Part A and B. And I think this was such a good move and so important because it's not just about Medicare Part A and B anymore. Medicare Part C and Medicare Part D is important. Usage of this new model form is very important. I'm going to talk about that in a moment with regard to Social Security numbers. Here it is. Myth number 6. Documentation of your attempts to obtain Social Security numbers is not critical. It's extremely critical. The recent NPRM, the one I talked about earlier, where Medicare will set out to fine RREs for failure to comply with Section 111 requirements, it was indicated in the NPRM that failure to document good faith efforts to obtain an injured individual's Social Security number can be a sanctionable event. And within this NPRM, and again, the NPRM is not final, right? So Medicare can update some of these parameters in the final rule, but it's indicative of what Medicare is looking for. In this NPRM, CMS proposed a 3-step process that they would want to see in your claim records that parties underwent to try to obtain a party's Social Security number. And it's pretty in-depth. They want to have you contact that individual by mail twice and at least once by email or phone. So that's a pretty lengthy process. Right now, the model form can be used instead of all 3 of those steps. But if that final rule comes out and requires those steps, very important. Previously, I've done some auditing of clients and I've seen a lack of consistency in collection of Social Security numbers or consistency. So very, very important that we do that. But the final rule will indicate whether this 3-step process will be required. And I know that in the responses to Medicare's proposed rulemaking, parties indicated to Medicare that this 3-step process might be a little bit burdensome. And again, in the meantime, this is not a final requirement. We can use that new model form from CMS. If you cannot obtain the Social Security number, make sure you have that in your file and signed. Make sure you're documenting your good faith efforts to obtain a Social Security number. And it's also really important. I've stuck a myth within a myth. A myth is that Medicare beneficiaries are only 65 and up. So here's another issue I've seen amongst RREs. They may only query individuals that are 65 and up. Individuals can become Medicare eligible under 65. One of the main ways they do that is through Social Security disability enrollment for 24 consecutive months. So pretty much any age above about 20 years old can be enrolled in Medicare. You should query everyone to play it safe. Also, you should audit your Medicare claims to ensure adjuster collection of SSNs because we want to make sure it's consistent. It's not worth being lodged a civil monetary penalty. Myth number 7, reporting and conditional payment responsibilities can be shifted to Medicare beneficiary attorneys. No, the responsibility to report under MMSEA is absolute for responsible reporting entities, and failure to comply can result in civil monetary penalties of up to $1,000 per day per claim. Although a Medicare beneficiary may self-report, it does not satisfy Section 111 requirements. And again, I talked about this earlier. Although it's acceptable and not so unusual for Medicare beneficiaries to lead the charge in reimbursing Medicare and agreeing to indemnify, primary plans can still be held responsible. And it's really important if you find out that there has been a self-report, that you find out what was reported, because there can be multiple conditional payment recovery files opened due to a self-report and due to the RRE's report, and it can become confusing as far as what the actual accepted injuries are. So it's important that primary plans control the responsibility to report and also I always recommend that the primary plans, as the deep pocket, control the reimbursement to Medicare via a direct check. Now, again, this could be different in every settlement, and not every case are you going to allow, or Medicare beneficiary or their attorney is going to allow the primary payer to reimburse. But in most scenarios, it's a good idea to avoid those double damages. So ask the Medicare beneficiary attorneys about any self-reports to the BCRC. Ensure any inconsistencies are clarified. The RREs need to report despite the beneficiary reporting, and controlling the reimbursement process is the only sure way to ensure no double damages. And as I said earlier, a direct check to Medicare is highly recommended from the primary plan. Myth number 8, MSAs are only for Medicare beneficiary and work comp settlements. I'm going to talk about another notice of proposed rulemaking, although this one is it's still in pending. It's currently posted on the OIRA website. It's known as the Medicare Secondary Payer Classifications and Updates, or Clarifications, excuse me. We all know of it as the LMSA rule. So Medicare has been talking about for a number of years implementing parameters around Medicare set-asides for general liability claims. Medicare has been unequivocal in their communications over the years that just because there is a review process for workers' compensation Medicare set-asides does not mean you don't need to protect Medicare's interests in liability claims. This NPRM was slated for release, or at least currently it says it was slated for release in March of this year. So at any point in time, we could receive this framework from Medicare on MSAs and liability claims. But again, it's clear that Medicare is working towards setting up an LMSA review process. We've seen the common working file, which is that field for each Medicare beneficiary indicating primary plan information, and they carved out a field for an LMSA amount. They've also issued notices to medical providers letting them know that if there's an LMSA available, to bill the LMSA. We also know that the current contractor reviewing workers' compensation Medicare set-asides, the WCRC, has a requirement to review LMSAs and NFMSAs, no-fault MSAs, if and when they release a process to do so. So the contractor would review it. A number of years ago, too, we saw this informal handout by a woman named Sally Stalcup. It was an informal handout out of Medicare. And she had received so many inquiries about what an LMSA is needed. And she said that the parties have to determine, is there a funding for future medical in that settlement? Is there a release of future medical? If so, there needs to be a protection of Medicare's interests. And then in 2011, we saw one memo issued from CMS around LMSAs, and that let parties know that if you have a treating physician certification, which states that no future injury-related care is needed, then the parties don't need an LMSA. But it left ambiguous when parties do need an LMSA. And again, though, all we can look to is the Medicare Secondary Payer Act and the informal guidance and say that in certain scenarios, it's important to look at the big picture in liability claims. Perhaps those higher dollar settlements, you should consider some form of an LMSA or a future medical allocation. Even though CMS will not currently review it, this can show that the parties have protected Medicare's interests. Similarly, working with an MSP expert on setting best practices and determining settlement strategy and liability claims is recommended. Just remember that these claims are going to be reported to Medicare via Section 111, right? The settlements are going to be reported. And so we want to make sure that we've protected Medicare's interests, reasonably so. And until Medicare releases that NPRM and we have further guidance, parties should do what's reasonable to protect Medicare's interest. Myth number 9, those claims that are under CMS review threshold do not require a WCMSA. We're all familiar with the scenarios in which Medicare will review a proposed WCMSA, right? I have them listed here in the first bullet point. But what if your settlement does not meet CMS's review threshold? Let's say you have a Medicare beneficiary with a $20,000 settlement, or you have a settlement with someone reasonably expected to be on Medicare within 30 months of the settlement, someone who's on Social Security disability, and your settlement is $200,000. In both of those scenarios, Medicare will not review a proposed MSA, but that does not mean it's a safe harbor from protecting Medicare's interest. Within the WCMSA reference guide, Medicare notes in several places that it's a workload threshold and not a safe harbor. And they actually provide two examples, which are very similar to the two that I just provided, of settlements under threshold. And Medicare states in these examples that failure to provide some kind of future medical carve-out or allocation could subject the entire settlement to CMS recovery. So very important that there is protection of Medicare's interest. And I'm not saying that all settlements under review threshold require an MSA. It's a matter of determining how much future medical is needed and what the settlement amount is. One point I want to bring up are settlements for $24,999. I've seen this time and time again over the years where parties think they're being cute and settle below CMS threshold. I always reiterate the following. Even if your settlement was $25,000, CMS review is a recommended process. It is not mandatory. You don't have to submit. We don't need to play these games. Secondarily, Section 111 reporting is going to be required. Do you think it might raise some flags to Medicare that you've settled for $24,999 and avoided establishing an MSA? So there are better ways to go about protecting Medicare's interest. And so those claims that don't meet CMS review threshold may need an MSA. So again, think about how these claims are going to be reported to Medicare and if protection of Medicare's future interest is needed. Consider a non-submit allocation in certain scenarios. Medicare acknowledges non-submit MSAs when they talk about those two examples in the WCMSA reference guide. They acknowledge that such would exist to protect Medicare from recovering the entire settlement. And lastly, more on non-submit MSAs. Non-submitted MSAs, myth number 10, are not supported by the MSP and not legitimate. Sometimes non-submit MSAs have gotten a bad rep, but they are legitimate. The Code of Federal Regulations cites that if the settlement allocates a specific amount for future medical services, it protects the rest of the settlement funds outside of medical. Obviously, assuming that that amount is reasonable and based upon a defensible number, right? We can't just pick an arbitrary number. And again, Medicare has recognized in their WCMSA reference guide non-submit scenarios. Of course, if you meet CMS review threshold, you might want to consider, and you should probably consider submitting that MSA to CMS. But if you're below threshold, a non-submitted MSA is legitimate. It is a party's attempt to protect Medicare's interest, which is incredibly valuable. Again, don't pick an arbitrary figure. A non-submit MSA that is defensible is ideally evidence-based, well-documented, and supported in the file as to how it's allocated. Professional administration, of course, is recommended to make sure that those funds are protected. And the non-submit MSA should be based upon their anticipated need for future medical care. Ultimately, an allocation which is defensible and aims to protect Medicare's interest is optimal over establishing a bright line rule on MSA needs, which are dictated by CMS thresholds. Okay, well, we've gone through the 10 myths. I have to give my elevator pitch for my newly established Sanderson firm, as I mentioned, just newly launched, but really excited about leveraging my expertise to help all of you. I'm passionate about MSP, and these are some of the services that we are currently offering. And I would be happy to hear from you. I would be delighted to hear from you after this presentation as to how I can help you. And I hope that this has brought some ideas to the forefront, and I'm looking forward to future conversations with all of you. I have placed all of my contact information here. I would be really grateful if you subscribe to our blog. I love writing. I'm having so much fun. One beautiful part about being on my own is that I can freely write and express, how I feel about MSP in the most direct way in guiding all of you. So please subscribe to the blog and future webinars. And again, thank you all for attending today. I'm going to go ahead and take some questions now. Okay, so we have a question. Is there any indication whether the fines will relate to claims occurring after a certain date, or will it relate to claims reported after a certain date? So what the notice of proposed rulemaking stated is that fines will ideally be prospective, right? So after the effective date of the rule. However, it relates to TPOCs that are reported or not reported. So there's a potential that if parties failed to report prior to the effective date, then it may be subject to a fine. So to answer this question, the answer is more than likely it's not going to occur to historical claims, but we need to see, right? There's no final rulemaking just yet. Again, as I said earlier, a late report is better than no report. Let's clean it up. If you've got concerns about what you've done on Section 111 reporting, let's get the information over to Medicare. And so let's not try and make sure that we, are in line for when this rule comes out. Let's get everything cleared up. I've got another question here. If the liability policy provides med pay for 1 year, is the termination date 1 year from the date of loss or 3 years because that's how long Medicare can pursue? That's a very good question. Now, I want to make sure that we make clear Medicare's statute of limitations applies to Medicare. And it starts when Medicare is notified of a settlement, judgment, or award. That's when the clock starts ticking, right? So let's say that as a Medicare obligation or restriction, right? As far as termination for your ORM and from the date of loss, now, if your med pay is only for 1 year, you're going to terminate that ORM after the 1 year because that's how long your policy is applicable and open for. Don't worry about Medicare statute of limitations. After you terminate that ORM after 1 year and that med pay policy lapses, then at that point is when the 3 year starts on Medicare's side. Okay, a couple more questions. Okay. This is a good one. As a no-fault RRE, we find it difficult to terminate ORM in several scenarios due to the strict guidelines for termination by CMS. Are these restrictions expected to be loosened in the future? And I have an example here. Let's say an auto claim in New York with $50,000 coverage and it does not exhaust. There's no time limits and we're unable to obtain a written statement from the beneficiary treating doctors to confirm no future treatment. ORM for these cases stay open indefinitely. I feel your pain. I feel your pain. I know that it can be difficult in states that have ongoing responsibility for medical for lifetime and no fault claims. I can tell you that several organizations are working with CMS on loosening these restrictions. So to answer your question, I hope so that in the future we'll have some of these restrictions loosened. Medicare is open to ideas around frameworks for doing so, but currently you need to keep ORM open indefinitely until that changes. I had a question about a copy of the slide deck. Yes, I don't plan on sending this out to everybody en masse. If you would like a copy of the PowerPoint, please email me at heather@sandersoncomp.com after the presentation, and I would be happy to provide a copy of it. Okay, another question. If we know the statute of limitations in a particular state runs after a specific or defined time, with the new rules, do I understand we're able to report ORM termination at the time of statute of limitations? For example, the Florida SOL is 1 year from last treatment, 2 years of data injury. Are we allowed to report that future date? Yes, that's the beautiful part of it, right? So if you know that under your state statute of limitations that you have a time frame in which you are no longer responsible for that ongoing responsibility for medical, particularly in Florida, yes, use that. Medicare is deferential to when you have determined you are responsible for medical. And when that terminates, then that goes, right? So yeah, and if you have further questions about that, please let me know. One last question, and then I'm gonna let everyone get back to their day. I had a question about a work comp case in which there is a $150,000 settlement with a Medicare beneficiary, and the parties want to know, can we settle without CMS approval? Well, as I mentioned earlier, technically it would meet CMS threshold for review. You can submit, but it's not required. The other follow-up question I received on this is, does Medicare have an enforcement mechanism to enforce non-compliance? It's a good question, right? We've not really seen Medicare set aside questions or non-submit. Of course they have an enforcement mechanism though. That's what the MSP is about, right? They can recover the entire settlement or coordinate benefits up to the entire settlement. And the other question was, is if